live streaming. Thank you.
All right. Thank you, everybody. Thank you for finding time in your schedules to do this remote hearing. This is Bar Counsel versus Lynn Brennan and Timothy Bradl. Before me is a motion to stay the pending hearing and start over. And I have responses from both Judge Brennan and Mr. Bradl. I've read everybody's papers. My plan today, this is a rather unusual procedural posture, I must admit. I read BBO Rule 3.18 to say that any motion to stay proceedings once a hearing has already commenced has to come before the board chair, which is me. So this is my plan for today. I am going to hear very briefly, I'm going to ask the two remaining hearing officers, Mr. Pollack and Mr. Taylor, a couple of questions after they're sworn in. And then I'm going to dismiss them. I am not going to allow any inquiry by counsel of Mr. Pollack or Mr. Taylor because I'm concerned that it would intrude on the deliberative process. After I dismiss the two hearing officers, I will then hear oral arguments from Bar Counsel starting first since it's her motion, and then Mr. Bradl and then Judge Brennan. In that order, and because the papers were so helpful, I'm going to limit oral argument to about 10 minutes. Does that seem like a fair way to proceed in this matter? Any objections to that order of proceeding? Okay, no. Hearing none. I will say that it's highly unusual.
Bear with me. I believe Attorney Mulvey's raising her hand, but you just need to unmute yourself, please.
Ms. Mulvey.
Hit the microphone button. And Mr. Hoops, her co-counsel, I believe, is going to her rescue. Bear with us one moment. Thank you again for your patience.
Okay, never mind. I found the hotkey. Mr. Cassidy, I'm sure Attorney Brennan appreciates the promotion, but she's an attorney, not a judge.
Oh, I'm sorry. I misread the papers.
That's
sorry,
all right.
Ms. Brennan. Thank you for clarifying. Any objections to the order of the proceeding? Okay. I do think it's very unusual, I will say at the outset, to have a hearing officer resign mid-hearing, as Attorney Sadeghi did. But I do not think that I can undo that. I don't think I have the authority to undo that, nor do I think it would be in the best interest of the bar or the public to force anybody to serve on a hearing committee who doesn't want to serve on the hearing committee. So I'm going to take that withdrawal as a given, and as I fashion an appropriate remedy here, consider that as water under the bridge, unless in the oral arguments any counsel disagrees with that premise as well. All right, so first, Ms. Travis, have we already sworn in Mr. Pollack and I'm sorry, our second, Mr. Taylor, have we sworn in the two hearing officers?
No, they have not been sworn in. I have checked their picture IDs.
Terrific. Well, could we swear them both in now?
Sure. Gentlemen, if you'll please raise your right hand. I do not see Mr. Pollack. I think it's just the way the screen is.
I saw him a moment ago.
I can see myself, if that helps.
Yeah. I can see him and his hand is raised. There you go.
Okay, now we went to a smaller screen. Okay, gentlemen, do you solemnly swear the testimony about to give in the matter now at hand will be the truth self you got?
I do.
Thank you.
Thank you very much, Ms. Travis. All right, let's go in alphabetical order. If we could start with our hearing panel chair, Mr. Attorney Pollack. Attorney Pollack, I'm going to ask you just a few questions. If you're unable to answer them yes or no, would you just please explain that you can't answer, and I'll try to rephrase the question?
Of course.
Thank you. My first question is, have hearing officers Sadehi's comments to you in this case prior to her withdrawal, either on the record or off the record, caused you to form a final opinion on the ultimate issues to be decided?
No.
Are you able to listen to the remaining evidence in this case with an open mind?
Yes.
Are you confident that you can remain impartial in this case until the close of all the evidence?
Yes.
Okay, thank you very much, Attorney Pollack. Mr. Taylor,
Yes.
I'm going to ask you the same questions I asked Mr. Pollack, and I'd just remind you, if you can't answer the question yes or no, just tell me and I'll try to rephrase the question.
Okay.
Have hearing officer Sadehi's comments to you in this case prior to her withdrawal, either on the record or off the record, caused you to form a final opinion on the ultimate issues to be decided?
Absolutely not.
Are you able to listen to the remaining evidence in this case with an open mind?
Yes.
Are you confident that you can remain impartial in this case until the close of all the evidence?
Yes.
Okay, thank you, Mr. Taylor. Thank you both for your service in this case. I know it's been 6 days and there are more to come, potentially, depending on how I rule in this case. So I just wanted to thank you both for your service and for your patience. At this point, I think it's best to dismiss you both. Because what's left is an argument before the board, and I want you all to have the ability to stay neutral if the hearing resumes in front of you. So I think it's best if you not hear the oral argument.
Sure.
Thank you.
Thank you both for coming today.
Already. Bye-bye.
Bye.
Michelle, have they departed?
Yes, sir, they have.
Oh, terrific. Thank you very much.
You're
All
welcome.
right, Ms. Harbison, your motion to stay the proceedings and panel a new hearing panel. I'll hear you for 10 minutes.
Okay, I don't think I'm going to take that long, but thank you very much for allowing me this opportunity. And I also want to thank you for your time and for arranging for this hearing. As you know, a hearing committee member, unprompted and unsolicited, made remarks on the record that were clearly biased to Bar Counsel's case. And Bar Counsel at that point had not completed presenting his case in chief, and all of the evidence was not yet in or presented. And so in light of that unprecedented and clearly prejudicial activities that happened made by that hearing committee member, Bar Counsel took the reasoned approach to request that the hearing be suspended so that we could figure out what to do next. And I will also note for the record that there was only approximately 1 hour of scheduled hearing time left at the time that I requested a suspension of the hearing, and no further dates or times had yet been scheduled. So there has not been any prejudice at this time. Despite the hearing committee members' resignation, and I agree with you that that is not something that can or should be undone, Bar Counsel still needed to know more and therefore filed this motion. We have obviously no window into what was said and when, and what influence, if any, that had on the remaining committee members. And that's why we're here today, to learn more. And I do want to bring to the chair's attention a recent case from the SJC called Commonwealth versus Vasquez. It was a 495 Massachusetts 279. It's a 2025 case in which there were allegations of bias by a juror, and the court found that the judge was required to make a meaningful inquiry into the statements that were made. And in that case, it hadn't been done. So the murder conviction was overturned and a new trial was ordered. So I'm extremely appreciative of you, Mr. Chair, having taken this matter and this motion seriously, and to conduct a voir dire of the remaining hearing committee members. We're keeping an open mind we've just now found out, based on their sworn testimony, that they feel that they can continue. And I would like to have a moment, or 24 hours of a moment, to confer with Bar Counsel should you require anything further from us at this time. Otherwise, I just thank you for your time and for your consideration of this very serious matter.
One question, Ms. Harrison.
Sure.
And maybe you don't want to answer this before consulting with Bar Counsel, in which case I'll gladly give you 24 hours. But to the extent you can answer today, assuming I was inclined to rule against you on restarting the hearing before an entirely new hearing panel, would Bar Counsel have a preference between continuing this hearing before two hearing officers who have already heard 6 days of testimony, or reading in a third hearing officer and reading that person in on the transcripts and having 3 hearing officers decide the case?
I have no authority to speak on that, so I do want the 24 hours if possible to confer with Bar Counsel, and we will file something in writing with respect to that.
Okay,
option.
Thank you very much. I appreciate your candor. All right, so Mr. Respondent Bradl, Mr. Hanley, are you with us?
Yes,
Okay, I'll hear you, sir.
sure. So,
By the way, before you start, Mr. Hanley, I just wanted to say that I read Rule 3.18 to not give me any jurisdiction on your renewed motion to dismiss. 3.18B6 says that once a motion to dismiss has been decided upon by the board chair, it may not be reviewed or appealed other than as provided by the rule, which of course is only respondent's appeal if the motion is allowed. So I don't want an extensive argument on all the reasons why this case should be stopped or your client has been prejudiced by the delay, which I considered very carefully when I decided the first motion to dismiss. Unless you think I'm wrong about my reading of Rule 3.18, that I don't have jurisdiction to entertain a renewal of that motion. I will hear you on that.
Well, as I think you said at the outset, and I'll keep in mind what you're saying to me, but what you said at the outset, this is very unusual circumstances procedurally. We have a hearing that was stopped unilaterally by Bar Counsel. The transcript speaks for itself, but Bar Counsel indicated she was not going to proceed and was stopping the hearing. And I understand that a motion to stay needs to go before the board chair, but no motion to stay was filed for another, 8 or 9 days. And so it's in that posture that we have a stopped hearing, and there's a request for a stay, which is really a request for a mistrial. And what we were saying is that where Bar Counsel has effectively abandoned mid-hearing its prosecution, the case should be dismissed, and we were renewing the motion to dismiss. So in those unusual circumstances, I don't see how it goes before anybody else but you. But I so that's I think how I get there. In this hearing, and part of why we spent time in our memo focusing on it is that if we were here, and as we asked Attorney Sadeghi to return to the panel, but part of that was also to make the point that what she said is no different than what has been said by jurors to court officers and judges, what has been said by judges in bench trials as they sort of try to corral the hearing and try to focus on what is important, that this is no different than what happens in courtrooms all the time. And the rules are obviously loosened to some extent in a proceeding like this, but they're drawn from what happens in courtroom. We draw from what happens or what our appellate courts decide. And so what she said was not. I would suggest that if she was still on the panel, she would not be required to be removed. And the first step that should have been made was a motion to recuse, which when the respondents moved to recuse this attorney, and ultimately she satisfied us that she could remain impartial based on an issue we raised, the hearing went on. But it should have been, that should have remained with the hearing committee. But now that we're here with you, we're asking for more. This hearing committee member resigned but did not recuse herself. And I'd suggest that I understand the practical reasons that may be present for not asking her to return, but there's a chilling effect on these volunteers when, you know, they're saying, hey, we're going to report, we think what you did is serious, and we're going to go talk to bar counsel about that. Other than Mr. Taylor, who's not a lawyer, the lawyers that serve on these committees, we're all licensed by the Commonwealth of Massachusetts. We all have a healthy fear of bar counsel. And so when that happens, it sends a chilling effect. And 2 days later, without any motion filed, that hearing committee member resigned. And we'd suggest that is significant. And it's why we went to the step of saying this case should be dismissed. But if not dismissed, and if she's not asked to rejoin, I'd suggest that going forward with the 2 hearing committee members who have heard 6 days of evidence. There are only 4 witnesses who testified over 6 days, and one of them was only, 15 minutes. So it's really 3 witnesses in 6 days of testimony, significant witnesses. The opposing counsel to Mr. Bradl in the trial that's at issue from 20 years ago testified. A representative from the Suffolk DA's office that handled this post-conviction matter testified, and the defense attorney in 2021 that handled Mr. Jenkins' case testified. The ability for these witnesses to have been sized up, where 2 of the witnesses weren't there when the alleged misconduct happened, and one was, his memory was terrible. So the fact that these hearing committee members heard from these witnesses is significant. Their testimony can't be submitted to anybody else. We don't want anybody else to sit on this hearing committee that wasn't there for their testimony. There's a reason we have we have live witnesses. And we wish to, if we have to proceed, and Attorney Sadeghi doesn't rejoin, to proceed with these 2 hearing committee members. It's been great delay in this case, great delay in getting to a hearing, and we don't want any further delay if we must proceed. And so these hearing committee members are the right ones to hear it. There's not going to be better evidence for bar counsel with another hearing. It's going to be these same 2 people who weren't there, and one person who has very little memory, no physical file, no electronic file, huge deficiencies in the evidence. And we want the hearing, if it's not going to be dismissed, to proceed with the 2 hearing officers who just told you that they can be impartial.
Okay, thank you, Mr. Hanley. Ms. Mulvey or Mr. Hoops, who do I have the pleasure of hearing from today?
I guess you're stuck with me probably now that I figured out how to unmute.
Okay.
I would echo the feeling that it's incredibly regrettable that we are in this situation. Attorney Sadeghi was incredibly attentive. She asked, as the record will show, many very perceptive questions, showing a command of the documents and the detail. And I think it's hard not to see that she was essentially bullied into resigning by the threat of some sort of public shaming. I'd echo Mr. Hanley's comments about the fear, the healthy fear with which most lawyers view the office of bar counsel. And I think it's an incredibly dangerous precedent to set, to allow hearing officers to be bullied off the committee by bar counsel's displeasure. That said, we're here. I certainly think it would be open to you as the chair to question Attorney Sadeghi, to ask her questions similar to what you asked the remaining 2 hearing officers, and to ask an additional question whether she feels that any of the events have biased her or made it impossible for her to keep an open mind, and whether she would like, under the circumstances, to retract her resignation and return to the panel. Obviously, I think her answer to that question has to be respected one way or the other, no matter which way it is. But I think it would be entirely appropriate, if she feels like she could come back fairly, and she may not, given everything that's happened, to ask that question and get a panel that's an odd number rather than an even number. With respect to the 2 remaining hearing officers, your questions mirror exactly what a judge would do to a juror in a similar situation. You received appropriate reassurance that they can continue to serve. And again, as with a juror, I think that should be the end of the matter. The Vasquez case, if it's the one I'm thinking of, I believe had a racial overtone to the issue, and it was an issue among jurors, that there was some conflict or some strife between jurors that, as I said, I believe has a racial overtone. Again, by analogy to Section 606 of the Mass Guide to Evidence, that has a whole different set of rules. I don't think there's any suggestion that rubric applies here. I also think this is really more analogous to a situation where a judge is sitting jury waived and says something indicating a view of the evidence. I suspect we've all had that happen to us, where a judge says, "Aren't you going to settle this?" Or, "Counsel, I think you ought to cut that witness short. He's not doing you any favors." All kinds of things got said. As both of us submitted in the papers, there's a legal distinction that's critical between opinions formed as a result of listening to evidence and opinions that are formed based on some extraneous indication or influence. I don't think we have in this case any indication that there was any extraneous influence operating on Attorney Sadeghi or anybody else. With respect to where we go from here, I don't believe that this is asking for a review of a Rule 3.18 decision. I think we have a new set of circumstances with additional grounds that, in essence, involved bar counsel deciding not to proceed. And I don't think the fact that it's an hour or a day or whatever matters. In essence, bar counsel unilaterally decided she wasn't going to present evidence. And again, my only experience is in a trial court, and I can't imagine that saying that to a judge and getting anything other than a directed verdict. So I do think you have the power to decide the renewed motions given the new grounds. And I'd ask for dismissal, again, because I think this is such an extraordinary situation that, from a point of public confidence and getting hearing officers to serve, we just can't let this happen. This just isn't right. And finally, with respect to the 2 versus 3, the evaluation of demeanor, especially where you have witnesses who are not percipient witnesses, but who are, in essence, giving opinions about things that happened 20 years ago, and drawing inferences, the ability of the hearing officers to observe those witnesses, ask questions of those witnesses, and make judgments based on what happened in the hearing room is irreplaceable. And reading in somebody with a transcript is not a substitute. And as a last point, as I said in the memorandum, there are 100 and some exhibits covering thousands of pages. A lot of the testimony so far involved the hearing committee members following along with a document while the witness testified. So it's not a simple matter of somebody reading the transcripts and being caught up. Somebody would have to take the transcript, find the exhibit, match them up, and follow along, which is a far more time-consuming process that I don't think we should subject somebody to. So I think beyond that, I would rest on what we've already said, and I thank you for the opportunity to address you.
Thank you. Ms. Mulvey, one question. You emphasized demeanor evidence. What if we did proceed with 2 hearing officers and they were divided on an essential issue of witness credibility, and they came out on opposite sides of the alleged violation, largely hinged on an assessment of credibility? What would the board do with that on review?
I think that that's a hypothetical situation that I bet we all hope doesn't happen, but would probably be better addressed in real time, knowing what the dispute was. If it were a fairly discrete point, I could envision bringing in a third tiebreaker and repeating or having a witness testify for, a half hour or whatever it took to resolve that specific point. I think it's so fact specific that it would be better not to speculate about what we do and preferable to address it if and when it happens.
All right, thank you. Ms. Harbison, I do have one final question for you. How many more witnesses do you anticipate calling, or if you would prefer not to answer the question that way, what percentage of your case do you think these 6 days of testimony have already taken up?
I have a couple of points I'd like to make on that question. The first answer, the straightforward answer is I have both respondents that I'm planning to call as the final 2 witnesses. So
okay, so you think you have 2 more witnesses?
2 more witnesses. Okay. Yes. But I would like to point out that the reason, if you look at the transcripts, that this hearing has taken such an extraordinary amount of time is not due to Bar Counsel's presentation of the evidence. It is due to the respondents asking the same question 5, 6, 7, 8 times and going down rabbit holes that I find objectionable. I've made the objections. They've been generally overruled and everything's come in. So that's just the way that this hearing has played out. But to place it on, on Bar Counsel and saying that I refused to proceed when I was saying that I wanted to have the hour to discuss with Bar Counsel and that we could pick this up after this board decided on whatever we decide, motion we decided going forward. So, I also think the ad hominem attacks on me as being a bully and causing Attorney Sadeghi to resign is inappropriate and untrue. And finally, I would say that Attorney Sadeghi said on the record that she had made these statements after the first day of hearing. There was almost no evidence presented on the first day of hearing. That was because the respondents had decided that some private correspondence between the defendant 20 years ago and his trial counsel, correspondence between them, which was protected by attorney-client privilege, should be turned over. And there was much argument about this. And so that's what took up the majority of the first day. So, and then Attorney Sadeghi said she had made comments after that first day. So it wasn't in response to any evidence that Bar Counsel presented. This was clearly something she had made her mind up upon reading the petition, or just because she, whatever, I don't know what the reasons were, but I just really feel that needs to be clarified. Thank you.
Thank you. Mr. Hanley, Ms. Mulvey, any objection to giving Bar Counsel 24 hours to answer my question in writing as to the 2 possible alternatives here after consulting with Bar Counsel?
No.
Mr. Hanley? No.
And Mr. Chair, May I add one additional comment to Ms. Harbison's comments?
You may. Can I just finish my thought?
Absolutely. Sorry,
Thank
Mr.
you
Chair.
so much. Ms. Harbison, in your writing that you're going to file tomorrow, please limit it to the question of how to proceed, assuming we proceed. I don't need a regurgitation of that
Understood.
we should start the hearing over. I've heard you on that, and I've been the beneficiary of your papers.
Okay, thank you.
Yeah, Mr. Abadi.
Thank you, Mr. Chair. I did want to add some comments, particularly with respect to Ms. Harbison mentioning references to bully, references to intimidation, references in papers to a gorilla. I first want to fully echo and support Ms. Harbison and her arguments in this case. But I also want to address very briefly the comment that what this proceeding and this motion stands for. I take very seriously the bar discipline process, and I do want to comment that this motion was filed in reference to that. Our profession is largely self-governed by lawyers, while non-lawyers from the public have some voice in the bar discipline process, and it's a very important voice in helping us decide which lawyers should have their licenses restrained in some way. The signature of the bar discipline system, one that I am very proud of, is that we lawyers, we hold each other accountable. And for this system to work, it must appear beyond the reproach to the outside world. I can tell you that I personally regularly hear from clients who feel let down by this bar discipline system because they feel like it's an insider's club, a club where lawyers won't hold their peers accountable. And we, as stewards and protectors of the bar system, we have to fight that appearance at every turn in the system. So I would venture to say that it should not be controversial to say that a hearing officer who displays deep-seated favoritism or antagonism towards one side's case in the middle of a hearing should not continue in that case. And I would rely solely on the comments in the record from the hearing officer who has recused herself to decide whether that in those comments, particularly with respect to maternity leave and bar counsel's case, reflected some bias. I would say that it is obvious that there was some deep-seated favoritism or antagonism towards bar counsel's case. Now, I would say that that is what bar counsel was presented with when these comments were made totally unprompted, totally uninvited on the record. And she revealed these deep-seated sympathies towards respondent Brennan's case. Any party on the receiving end of such personal antagonism towards their case, whether it is the Office of Bar Counsel or Respondents Counsel, certainly in those circumstances would feel that they would need to respond with a motion to recuse that hearing member. And if that hearing member also volunteered unprompted that they made comments off the record in private to other hearing committee members, I would venture to say that any counsel in that situation, whether they be bar counsel or the respondent, would feel absolutely compelled to file a motion to stay the proceeding, to recuse the hearing panel members, and have an opportunity to at least inquire as to what happened. What is the basis of these comments? How are these comments shared with the hearing panel members? What were the hearing panel members' reaction to those comments? And the SJC case that was cited is a perfect example of why it's important to hold a proceeding like we're having today. And Mr. Chair, we appreciate that you calling this proceeding. We think it was a thoughtful, appropriate response to our motion. We appreciate the testimony that was given today. I will meet with Ms. Harbison immediately after this proceeding, and we will submit something within 24 hours. But I object on the record to the suggestion that the premise of the motion somehow is something that my office or the bar discipline system has to be embarrassed of or remorseful of. When I would submit to you, it's the opposite. We are doing our best to make sure that what we represent and what we put out to the public and to the bar is something that that we can all be proud of. So thank you, Mr. Chair.
Thank you, Mr. Abadi. Mr. Hanley, anything further?
No, thank you.
Ms. Mulvey, anything further?
No.
Ms. Harbison?
No, thank you.
Okay, thank you all for your time today. Thank you for accommodating your schedules. I expect you'll hear from me very shortly. There is no next date for this case. Is that correct?
Correct.
That is
Okay,
correct.
So you'll be hearing from me very shortly after I hear from Ms. Harbison. And then we'll get Ms. Risk to put it on the calendar as soon as possible in accordance with my order.
Thank you very much.
Thank you.
Thank you, Mr. Chair.
Have a good afternoon, everybody.
You too.
Thank you.
Bye-bye.
Okay, guys. Hi. I was actually originally just gonna stream this as is and get off, but I feel like it bears some explanation. So I'm not even really that well set up right now. Let me know if I have to adjust my gain or anything here. Hit squad that no. So you really need to understand the context would be important to understand. So this is attorney Tim Bradl. He is not only a very vocal Free Karen Read advocate at this point. I think Free Karen Read is actually suggesting that he's taking up the appearances and the mantle now that attorneys for Karen Read are gagged. And he's also Turtle Boy's attorney. And so why does this matter? This is a 20-year-old case. He was a prosecutor, an ADA for Suffolk County at the time, a young man by the name of Shaun Jenkins. And Shaun Jenkins was charged with and facing trial for murder. And so I've done a lot of research on this. I've known about this for a while. I honestly didn't realize they were having hearings that you could watch until a couple days ago. But Shaun Jenkins was a young black man, not from a good area, not a lot of money, projects, and he was selling crack. And his cousin, Stephen Jenkins, was as well. So Stephen Jenkins was found shot to death in his vehicle outside of his apartment building. And very quickly, Shaun was implicated. And the motive that they gave originally was that Stephen was undercutting Shaun with crack sales. And he had made comments that he, was going to kill him, and then he ended up dead. So this case goes on, and Shaun Jenkins, of course, is maintaining his innocence, and he is not Karen Read. He does not have the resources or the public support that Karen Read does. This is in the 90s. He's young, he's poor, he's black. Nobody's really talking about it. So he maintains his innocence, and there comes a possibility that Stephen actually owed, I think it was $3,000 to his crack supplier. And so the defense was mildly aware of this, but they didn't have any information. They didn't have the guy's name. They didn't know where he lived. They didn't have a phone number, nothing like that, phone records, all of that. So it turns out that Stephen had this drug debt. And one of the last people that he was in contact with was this drug dealer whom he owed the money, who apparently was also making comments that he was going to kill him. And the drug dealer lived just a couple blocks away. And the person that the victim was last seen with was a young man who matched the description of an associate of this crack supplier. So Bradl and his office became aware of all of this information about the potential third-party culprit, pretty much. And there wasn't a lot of physical evidence connecting Shaun Jenkins to this crime. So it was essentially the circumstantial stuff, and the motive obviously playing a large role in it. So they hid this information, and Bradl is in email recognizing that they have this information and instructing his office to hide it. We need to make sure they don't find out about it. So the defense is kind of pushing, going, hey, we've heard some stuff, but we need some more information. And Bradl and his office lied and said, well, we don't have it. They can't introduce a third-party culprit because they can't even produce who this third party is. We have no information about this person. And the entire time he did. Okay, so that's why he is facing disciplinary proceedings at this point. So what happens is the Board of Bar Overseers gets the complaint. If they determine that there's serious misconduct, then they refer it to their hearings board, and they determine what the punishment is going to be. So it's not a question as to whether or not Bradl has done this. He's done this, and now they're trying to figure out what to do about it. And why is this important? Because Bradl is essentially out here with the rest of the chorus accusing the Norfolk County DA's office of exactly the same conduct that he has been found sustained, right? Like he did this, right? And he has no evidence to the contrary. And he is, just next level grifting. He's going up in public and giving these interviews and decrying this. And this is something that he has done. And, we look at him taking the Turtle Boy case on right now, and has this behavior really changed? This unethical, win at all costs, don't care about victims really, because not only did Shaun Jenkins end up in prison for 15 years for a crime that he very well may not have committed. And that's the other part of this that really sucks, is he's never going to get away from that dark cloud now, because this case was not properly litigated. So could he be guilty? Yes. Could he be innocent? Yes. He didn't get the benefit of a fair trial because of Tim Bradl. And Lynn Brennan is the other ADA that's facing some sanctions here. But, she wasn't necessarily as involved in the hiding of evidence as Bradl was. She had actually made a comment internally in an email at one point about feeling uncomfortable even bringing it to a grand jury because we probably won't get it, right? So, but they did anyway. So he takes the Turtle Boy case, and is he still perpetrating similar behaviors? Is he proffering edited video and audio and saying that it's real? And is he shaming victims? Not only does Shaun Jenkins never get away from this really and has lost 15 years of his life, but the victim's family doesn't get any closure either, right? So I think this matters because when we're looking at the free Karen Reed camp and the people contained within Timothy Bradl being one of them, I think we really have to look at, are they being authentic? Do they believe in what they're saying? Or are they just saying things because it's getting them attention and it's getting them money and press time? And I think with Tim Bradl, it's pretty clear that, he's not being genuine. He's not being genuine when he talks about rights. He doesn't care about civil rights. He violated someone's civil rights and clearly is fighting tooth and nail with it, right? You'll hear a lot of the same things that we complain about in the Karen Reed trial and the Turtle Boy, case as well, being echoed just in this bar, disciplinary, setting right here, right? About the name calling and the accusations and the theatrics and, the issues with insiders clubs and bias, right? These are not ethical people. And yes, Maureen, it very well could be that the real killer got away. It's hard to say, right? And I don't know. I know that the evidence against him was weak enough and the misconduct egregious is not enough that his case was overturned and they declined to prosecute him again, right? And I know that the misconduct was egregious enough that the state settled a lawsuit with him. Whether that really, the guy's life is fucked, right? Like, this is the real consequence. And again, they're propping Karen Reed up and pretending that this is her life, her situation. Look at the difference between the two and understand, right? Like Karen Reed is miming real people's struggles, and the people that are supporting her, specifically in this case, are party to the same behavior that they claim to object. Nothing happened last night, Becky Doglover. Nothing happened last night. You don't have to be like neutral, okay? But like, you don't need to be. I have very strong feelings about this because, like, they put someone who was already disenfranchised in prison unjustly for 15 years, and like, yeah, great, he got a settlement and got some money. I bet his life isn't really great right now. This is not a fairy tale. This isn't Karen Reed that screams that she needs to be freed from the Omni Seaport Hotel eating her $90 steaks and then, is going to waltz out, and her life is wonderful if she gets acquitted. This is somebody who was convicted unjustly, went through the entire process, gave up 15 good years of his life too, because he was young, right? And nobody's even talking about him Nobody was out of the courthouse, 300 deep screaming free Shaun Jenkins, but this is what real injustice is. Karen Reed is using her privilege to mime this kind of injustice. Right, Emily gets it. And of course, it all comes back to the same toxic cesspool that Aidan Carney and Karen Reed have created. I mean, we can go into Alan Jackson's history at some point too, because we know how he handled victims in the Weinstein case, or how he handled victim witnesses in the Spacey case, or when he violated Marcy's law when he was still a prosecutor. These are people that don't operate with ethics, and it's unfortunate because there are attorneys that do. Exactly, Maureen. This is and I'm a pretty apolitical person. I don't really lean too left, and I don't lean very right at all, honestly. Kind of in the middle. I found that I can even jive with the libertarians these days on some issues, but you have to be blind or lying to yourself to not understand and recognize. Okay. Sorry, apparently Jake wanted to chime in there, but you have to be blind or lying to yourself not to admit that there is a history of racial disparity in our country, and we haven't completely caught up or rectified to that. And this is just a glaring example. Karen Reed is an egregious example of white privilege that still exists. Am I shocked that some lawyer named Bruce Rivers did a video and is going to follow the trial? No, at this point. All right. Yeah, it's a lot of what's confession through projection, I found, Paul. It really is, and it's gross. The evidence against Bradl, you can go. I posted on my Twitter the petition for discipline, which obviously has made it to hearing, so you can just kind of take that at face value because the board did, right? Mostly his own emails. Which is a good reason to know that with as much scrutiny has been put on this case with the Norfolk County DA's office, what these people are saying is happening is most likely not happening. And I only say most likely because I'm not right there. But I mean, if I was a betting woman, I'd put money on it at this point, because the truth is, with most corruption and any type of conspiracy, and I mean in the legal sense, not like the earth is flat and Karen Reed is innocent, but most of these things people end up undoing themselves. There's always some sort of paper trail. Otherwise, we'd never know about any of it, right? So, that's how he was caught. And after even federal scrutiny, the Norfolk County DA's office has found to be doing nothing of the sort. Okay, so yeah, and I'm trying to figure this out here, but it sounds like there is a woman who was on the trial board that made comments that were sympathetic to Lynn Brennan, who's like kind of a co-defendant. I'm sorry. I have a baby lion now, and she follows me around and just messes with the bigger dog. But Lynn Brennan is the co-defendant here in the situation. Is that what you call it? I don't know enough about the disciplinary process to know if they're respondent. I think they're probably respondents, but so the co-respondent. And apparently this woman, Pam, I can't remember her last name now, made some comments that were sympathetic to Lynn Brennan. And so that kind of stopped the proceeding for a little bit. So it sounds like that's a bias. And Attorney Abadi got up and very eloquently urged the board to, hold each other accountable. And, that's the thing is, like, I don't think that anything serious is going to happen to Bradl because it does look like an insider's club. Not for nothing, but people can reach out to the bar if they have opinions. So I'm not encouraging. On some level, I don't know. I don't want any like flooding or harassment or anything like that, but this is a situation where, like, yeah, maybe some more public light needs to be shed on it. And, I'm sorry that I didn't talk about Shaun Jenkins earlier. I only found out about this, honestly, in my own ignorance, related to Bradl when we were kind of trying to figure out who the hell this scumbag is that would be screaming about, his client's constitutional right to ruin children's sporting events. So I didn't know about it. And when I'm starting to read it and see what happened, like it's upsetting. And it's particularly upsetting because, you know, the way that the system actually works. And I think where maybe some people's misplaced passion in this is that the system doesn't bully wealthy white women with, you know, supportive families. It goes after the most disenfranchised of us. And it's not always a racial thing. There's lots of white people, Hispanic people, Black people that are kind of being ground through the system right now because they're poor, because they don't have the same advantages that somebody like Karen Reed has, right? Like, you know, at the end of the day, her intelligence and work ethic surely contributed to her success, but she was set up for it out of the womb. And some people aren't. Some people who are intelligent and skilled and work hard aren't set up that way. And those are the people that get stomped on the most. And that's really what we should be upset about. And, you know, what Tim Bradl and Lynn Brennan did and their office did is just absolutely horrifying on a fundamental constitutional level. And it's horrifying for everybody involved. Like I said, it's horrifying for Shaun Jenkins. It's horrifying for his family. You know, it's horrifying for his cousin's family and the public at large. You know, it's awful. And he should be held accountable. But I don't think that he's going to really be strictly held accountable. And in the interim, he's still engaged in unethical behavior, and he's out here. I mean, hurting innocent witnesses, the named victims in his client's case, the things that he says about them, the aggressive swipes that he takes. You know, even Turtle Boy's ex-girlfriend, Tim Bradl, got on the stand and called her a mentally unstable liar. He doesn't know that. He's never met this woman in his life. He's making these strong declarative statements about a stranger who is the named victim in his client's case. It's not ethical. It's not right. Saying, you know, tough shit, Mick Alberts. He actually said that. But I'm sure that's about as much as he cared about Shaun Jenkins too. Any other questions or comments before I cut this off? Because I really wasn't planning on going live, and this is not a good time of day for me. I have other shit to do, unfortunately. I'm going to try to condense some of this information down into an edited video, maybe, so that it's a little bit more quick. I also want to get my bearings a little bit more on the Jenkins case. I know I read a lot of his appeals a while ago, but as I recall, like I said, I don't think there was a lot of physical evidence at all that tied him to that crime. It was just mostly circumstantial. And there's, you know, other stuff that I didn't really touch on. There was a witness that was paid $100 to testify against him who later recanted. There were a couple other witnesses that, you know, later recanted. It's pretty fucked up. It's, you know, it's not the Karen Reed situation where she just blindly points around and says, I don't know, everybody else did it. Like this was, and again, there's usually a paper trail to this stuff. That's how it gets discovered. And that's just not what's happening with Karen Reed. And she's gotten a lot more scrutiny in public and everything else on her case than this poor man that wasted 15 years of his life in prison ever would have. Yeah. Okay. Let's all go back and do some research. Like I said, I'll probably put it, I've been having fun editing videos. So perhaps we can all do some research and then put something together that's kind of quick and digestible. And, you know, again, anyone can contact the Board of Bar Overseers if they have strong feelings about this. I don't know very much about Lynn Brennan other than my impression from the petition was that she was less culpable than Bradl, but that could be my bias talking to. So I don't know. A good place to start is read the petition on my Twitter. That's probably a good place to start. We'll all get this together and try to figure out what's going on. Yeah. Somebody asked, am I not able to continue with the Bradl hearing? It's over. That's over. So they're looking to stay the proceedings. It sounds like there was a little bit of an upset with a biased panel member. I mean, I deleted it, Jen McCabe. First of all, shitty fucking name. Like, imagine being that obsessed with somebody you've never met. But anyway, Like, no, how am I lying? Like, this is all public record. We just watched the hearing. I have directed you to go visit my Twitter page and read the petition for yourself. Like, there is no lie in this. Because you don't like the truth doesn't de facto make it a lie. I don't know what to tell you. Like, it's very, very frustrating dealing with some of you people. Like, I let you in here. I don't moderate you. Like, you are entitled to be as retarded as you choose, I guess, but it's frustrating for people with a brain sometimes, really. You talk, yes, Sean, the mental titan that he is, says crusty panties. Like, I mean, like, you don't add anything to any conversation, and then you wonder why most reasonable, rational people don't take you seriously. Like, this is why. Because you're going to complain about my vocal fry and erroneously claim that I am tanked at 3:55 in the afternoon, and then accuse me of lying. Identify one lie, right? And then, the sexual harassment seeps in, because that definitely makes you the smartest guy in the room. I mean, no, it doesn't hurt me. It hurts you. You're just not intelligent enough to recognize that. All right. Well, this has been fun. Anyway, yeah, let's figure it out. Let's do a little bit more research. Let me get a better handle on the Shaun Jenkins case itself. And I guess I'll stream the next hearing too, just because even though these people don't have the intellectual capacity to process what they're seeing, they still deserve to see it and understand what they're backing. Okay, bye.